Good afternoon and welcome. My name is Barry Lytle and I am Director of Advancement for the Jesuits of Canada. I would like to begin by acknowledging the Indigenous peoples of all the lands that we are on today. Even though we are meeting on a virtual platform, let us take a moment to acknowledge the importance of the lands which we all call home. We do this to reaffirm our commitment and responsibility in improving relationships between nations and to improving our own understanding of local Indigenous peoples and their cultures. From coast to coast to coast, we acknowledge the ancestral and unceded territory of all the Inuit, Métis, and First Nations people who call this land home. Let us remember and acknowledge the harms and mistakes of the past, and to consider how we can each, in our own way, try to move forward in a spirit of reconciliation and collaboration. Before I introduce our guest speaker, please welcome our Director of Communications, Jose Sanchez, who will explain how the question and answer session will work later in the presentation and also go over some technical details.
Thank you, Barry. Yeah, so just to go over a couple of technical items, please remember that you can ask questions through the question and answer button at the bottom of the screen or the top, depending on the device that you're on, whether it is a computer or a phone. You can use the button, enter your questions, and we will be answering them towards the end of the session. And then the second thing is that if you have any technical problems or issues, you can always reach me through the chat box. Also through the button at the bottom or the top of the screen, the chat box button, and I will assist you. That's it. Thank you, Barry.
Thank you, Jose. It is now my great pleasure to introduce our presenter today, Ms. Rosanne Rocchi. Rosanne is Associate Counsel with Miller Thomson, a law firm here in Toronto. She has extensive experience in all areas of wealth transfer and management, including business succession planning, and family shareholder dispute resolution, as well as areas of tax, corporate, and trust law. She has considerable experience as well with pension trusts and benefit trusts, and recently became involved in helping with the restructuring of trusts for some Indigenous communities of Canada. She's a frequent speaker, author, and contributing editor of the Personal Tax and Estate Planning Journal, and is past editor of the Estates, Trust, and Pensions Journal. She is a member of the Society of Trust and Estate Practitioners and the Canadian Tax Foundations. Her accolades are many. She was listed as one of the best lawyers in Canada in trusts and estates, and in the Who's Who Legal Canada in both 2015 and 2020. She was also listed in Women in the Lead from the National Ivy Women in Management newsletter directory. Rosanne has served on the Board of Governors for Regis College and the Collegium of the University of St. Michael's College. As a director of RTIM Management, an investment management subsidiary of the Royal Bank, a governor of the Tax Foundation, an alternate governor for the Toronto Maple Leafs Hockey Club, I will not hold that against her, and the Toronto Argonauts Football Club. Her professional memberships include the Society of Trust and Estate Practitioners, the Canadian Bar Association, and the Canadian Tax Foundation. She knows her stuff. After completing her BA at the University of Toronto, Rosanne received her Bachelor of Laws and Master of Laws in Taxation from Osgoode Hall Law School at York University. She was called to the Ontario Bar in 1978. So please join me in welcoming our presenter today, Ms. Rosanne Rocchi.
Thank you, Barry. Hello, everybody, and welcome. You've taken the first step in something that people tend to avoid. Everyone worries about their estate planning, but they often don't do anything about it. It's as if you take a step toward your estate plan, the next day you will get hit by a bus. So people frequently avoid actually plunging into their estate plan. So congratulations for taking the first step. So on this screen, you're going to see an overview of what we're going to discuss. So part of your estate planning involves not just your will, but also a power of attorney for property, a power of attorney for personal care, gifts and pledges, the effect and implication on will planning of any of the gifts and pledges. We're also going to address probate planning, which is something that many people do to avoid probate tax, which is 1.5% of your estate. But in doing so, they frequently get into trouble that costs a lot more than 1.5% of the value of your estate. We're also going to address joint property and in-trust accounts. And we're finally going to discuss protecting a will from challenges. And at the end of these presentations, we're going to be open for questions. So if you could hold your questions until then, although if you have a question, I suppose you can send it immediately to Jose or through the question box that he referenced. So let's start with the continuing power of attorney for property. So this is a document signed during your lifetime and while you are capable, and it appoints an attorney to make decisions regarding your property and finances. The attorney, the person that you appoint, can do anything with your property that you could do, except for make a will. So they can do anything, but they cannot make a will, and they cannot do anything that would change the terms of your will. We'll talk about that shortly. People do a power of attorney for property and a power of attorney for personal care. Obviously, the power of attorney for property deals with finances. The power of attorney for personal care deals with personal care decisions. They do not need to be the same because different skill sets are required for each of the functions. And so frequently you will have one person serving as the attorney for property and another person serving as the attorney for personal care. This sometimes leads to disputes, and the principal issue where disputes arise is over care. So for example, the attorney for personal care may determine that you need additional medical care or additional nursing care. So they can make that decision, but the person who holds the power of attorney for property has to approve the expenditure. So that's where we get into problems unless you have made clear in your documents what are your preferences. A power of attorney for property can also provide for charitable gifts. Under the legislation, the attorney for property can only do what is in the best interests of the donor of the attorney, of the power of attorney. However, if charitable gifts had been made throughout one's lifetime, the attorney can continue these. Terminology, I probably should have started with this. The grantor is the person who grants the power of attorney. The attorney is the person who was appointed to act under the power of attorney and to make decisions on behalf of the grantor. This must be done before you are incapable. And incapable is defined as lacking the mental capacity to manage one's own property. Now, this is a higher standard of care to give a power of attorney for property than it is to make a will. It used to be thought that the highest level of competence or capacity was required to make a will, that the power of attorney requires an even greater level of capacity. And it means that you must be capable on a continuous basis, whereas for a will, you can have lucid periods and not lucid periods and still have capacity to make a will. The leading case in this area, Banks and Goodfellow, dealt with someone who was a schizophrenic. And during his lucid periods, he was capable of making his will, whereas during his illucid periods, he was not capable. That would not qualify for a power of attorney for property. The grantor must be over the age of 18. And you will be capable of giving a power of attorney if you know what kind of property you have, if you're aware of your obligations owed to your dependents, and again, a continuum is required and not just during lucid period. The person who is giving the power of attorney must also sign an acknowledgement that they know that the attorney will be able to do anything except make a will, know that the attorney must account for his or her dealings, and know that the donor, while he or she is capable, may revoke the power of attorney. You must also appreciate that if it is improperly managed by your attorney, your property may decline in value. This is a critical issue. And you must also appreciate the fact that the attorney may misuse the authority given to him or to her. And this is another critical issue. You can appoint more than one. So if you have any concerns about misuse or capability, you can appoint 2 people or more. A power of attorney will revoke an older one unless the document specifies otherwise. For example, one power of attorney can be limited to a specific property interest. So for example, in some specialized investments, such as limited partnership interests, you can appoint a limited power of attorney to deal with that interest only. You can also deal with a limited power of attorney to manage a bank account. In terms of formalities, it isn't something that you can just write on a piece of paper. You must have 2 witnesses present at the execution. And these are the same restrictions as for the power of attorney for personal care. You can write it out in your own handwriting, but it's not recommended. And there are forms. There are actually forms on the internet from the Ministry of the Attorney General, who is responsible for the management of property for people who are mentally incapacitated, so found. Conflict of laws. Your power of attorney made in Ontario is governed by Ontario law. Every province will have a separate statute dealing with powers of attorney. Ours is called a power of attorney. A different phrase may be used in other provinces. So if you have property outside Ontario, you should consider having a power of attorney prepared in that jurisdiction. So for example, if you have a condo in Florida and you spend a lot of time there, you might consider having a Florida lawyer prepare a power of attorney for property and for personal care according to Florida law. Okay, so the authority to act under a power of attorney takes effect immediately unless you state otherwise. So we distinguish between continuing versus springing powers of attorney. In a continuing power of attorney, which is the most usual one, there's no need to prove the incapacity. It takes effect right away. This avoids the need for third parties to have access to medical reports for the donor. And to avoid the problem of misuse, there are safekeeping procedures prepared by the lawyers to protect against early use. And in our firm, we generally have the material filed in our vault with a letter of directions from you as the donor to release it if you advise us, or upon a letter of direction from the attorney accompanied by a doctor's letter. Choosing your attorneys. This is difficult. Your attorney must be over 18 years of age. They may live outside the province, and you may select multiple attorneys. You can also appoint attorneys jointly or jointly and severally. So I would never recommend joint and several appointments. Joint and several means your attorneys can either decide alone or they can decide together. Now, if you have someone deciding alone, that gives the other attorney some pause because they may be responsible for actions taken by the other, even though they have had no decision making or no participation in the decision making. So that's something to look at if the lawyer asks you, do you want it joint or do you want it joint and several? My preference is to have it joint. You usually have two people appointed so that they can confer together and make a decision together and not alone. There may, however, be difficulty in signing documents if there are more than two attorneys or if they're not in the same location. So in that regard, you can authorize your attorneys to execute. One person may execute documents on behalf of both. So that would be a situation where everybody participates in the decision-making process, but only one person signs. If you have multiple powers of attorney, you have to consider majority rule versus unanimity. This would take place if you had 3 attorneys or more. And usually unanimity is difficult, so it's usually a majority that will rule. You can also select an alternate, and this is what most people do. They will appoint their spouse as the first attorney, and then they will sign a separate document as a multiple power of attorney, appointing, say, their children. And the intention is that it be used only after the spouse has either predeceased or is himself or herself not capable. The responsibilities of the attorney: they must account to the grantor, they must take reasonable care, they cannot act in conflict with the grantor's interest, and they can't personally benefit from their position. They can be entitled to compensation for acting, and this is a frequent source of friction. Attorneys must make the following expenditures: anything that is necessary for the support, education, and care of the grantor. They must also make expenditures that are necessary for the support and care of the grantor's dependents. And here we have problems that frequently arise as to who is a dependent, and they have to satisfy the other legal obligations. The attorney may also cancel expenditures. So it's not unusual to see attorneys canceling charitable pledges, which are non-binding, particularly when attorneys are also beneficiaries under the will. You might think that this is a conflict of interest, and it probably is, but it's done frequently. Attorneys are required to consult with the people who are serving under the power of attorney for personal care. Now, the attorneys for personal care will be in charge of living arrangements and care for the grantor, but they will not have access to funds for living arrangements. So decisions must be made in consultation with each other to ensure that sufficient funds are available. And again, as I mentioned earlier, there are frequent disagreements, particularly over the cost of home care and the quality of living arrangements. Authority to make gifts or pledges. The Substitute Decision Act, which is the statute in Ontario that governs attorneys' powers of attorney, permits an attorney to make gifts or donations to charity where there's an express consent in the document, or where there is evidence of similar expenditures made while the grantor is capable, but the total amount may not exceed 20% of the income or the maximum amount provided for in the power of attorney. Court approval is available to increase the amount, and these limits will not apply if there is a binding pledge. So if there's a binding pledge to a charitable organization, this is considered to be an obligation in the nature of a debt and would have to be paid. Okay, so the attorney cannot make a will for the grantor, nor can they change anything that will affect any testamentary disposition. So for example, most people, in order to avoid probate, will have a beneficiary designation under their RRSP or their RIF or their insurance or there might be an insurance declaration. Sometimes an RRSP is changed by an attorney to a different financial institution. So although the attorney has no right to designate a beneficiary, there can be a problem because after they've made the change from one financial institution to another, there is therefore no designation. So if the designation had been in favor of, say, a spouse, and then it's moved to another financial institution, there is no designation, but under the will, the spouse doesn't have an outright gift, but rather simply a life interest, that will be problematic. Attorneys may not make any gift expenditure that will impact the intentions of the grantor. Now that means that if there's a specific bequest in the will, such as a cottage, the attorney cannot sell the cottage because then when you read the will, the person who is expecting to receive the cottage will receive nothing because there's no longer a cottage. So there are also estate planning issues that may be undertaken depending on express authority in the power of attorney. So for example, alter ego trusts are very popular as an estate planning tool, or an estate freeze. That's really not permitted unless there's specific authority in the power of attorney. The Substitute Decisions Act specifies that the attorney cannot dispose of property that is subject to a specific bequest, as indicated earlier. So this rule does not apply if the disposition of the property is necessary to fulfill the attorney duties. So the cottage, for example, it may be necessary to sell the cottage to raise funds for a retirement home. And in that instance, you ask, well, what happens to the beneficiary who's expecting to receive the cottage? Well, there's something called redemption, which applies when the asset no longer exists. This is particularly problematic if the asset was promised in exchange for services rendered. So in that circumstance, I would think the prudent thing to do would be to go to court and seek court approval if there's a choice of assets to sell to fund the needs of the grantor, or to preserve whatever proceeds are available for the person who would otherwise be receiving the cottage. So for example, if the cottage is sold for $1 million, but only $300,000 is used, could the court order that the balance of that property be paid to the person who was expecting to receive the cottage on the death of the grantor? A power of attorney terminates on death, on the incapacity of the attorney, or if there's a court appointment of a guardian, if there's an appointment of a new power of attorney, or if the attorney revokes the power of attorney. So careful thought has to be given to both powers of attorney for personal care and property, and it's important to plan who they will be to avoid possible conflicts. Powers of attorney for personal care. The last time I gave this talk, we dealt with that first, and I made the mistake of saying we could take questions after each session. So almost the entire session was taken up with discussion on this. So I'm sliding it into the middle and hoping that it doesn't take up as much time as it did the last time. So again, the grantor is the person who grants the power of attorney. The attorney is the one who is acting. And incapacity in this regard means someone who lacks the mental capacity to make one's own personal care decisions. Now, this standard is fairly low compared to the capacity to make your property management decisions. The person who is appointed as the attorney for personal care has to make decisions regarding where you will live, and that includes staying at home versus moving to a nursing home, how you will dress, what you will eat, including mandated feeding, and what type of health care you will receive. There's also a statute in Ontario called the Healthcare Consent Act. And subject to this statute, the attorney is also entitled to give or withhold consent for treatment. Under the Healthcare Consent Act, unless there's a court-appointed guardian, the attorney is entitled to make such decisions ahead of relatives of the grantor. To give a power of attorney for personal care, you must be 16 years of age or older. So that's a lower age. You have to have the mental ability to know whether your attorney cares about you and that he or she may make personal care decisions for you. And this authority to act takes effect upon the incapacity of the grantor. And there are frequent challenges to the level of capacity as to when this is triggered. Again, like a power of attorney for property, it may not be valid everywhere. It may not be recognized outside Ontario. And again, if you have a vacation property in the US, you should consider having one made in accordance with the law where the property is situate. Formalities of execution, again, there must be 2 witnesses present at the execution. The witnesses may not be the people who are appointed as attorney or the spouse or a child or a person under the age of 18. Okay, the healthcare directive. This is the issue that takes up the most time. A healthcare directive is a statement in the power of attorney for personal care that reflects your views and wishes regarding the use of heroic measures to sustain your life. This can include DNR orders and end-of-life measures, or the healthcare directive may be excluded altogether. These are complex issues and beyond the scope of this discussion. And with my clients, I also give them the option of using one or more clauses, some are more specific than others, and invite them to discuss these issues with their doctor. I'll go back. Because I really do not know some of the technical issues. None of the lawyers really know technical issues involved in heroic measures. For example, with COVID, there's a clause in most healthcare directives and powers of attorney for personal care that says you don't want to have any measures which artificially prolong your life. Okay. Under COVID, if you were placed on a respirator, that counts as something which artificially prolongs your life. So a lot of people were saying, oh, I didn't know I'd excluded that. So again, you may have to discuss this with someone to say, all right, I know that I don't want to be kept alive if I'm in a persistent vegetative state, but there are things that happened before that time that you should discuss with your attorney and probably with your doctor. Again, these terminate on the death of the grantor, the death or incapacity of the attorney, the court appointment of a guardian, or the execution of a new power of attorney, which names a new attorney, or a revocation. Probate planning. Okay, I should tell you that lawyers make more money fixing problems caused by probate tax planning. So I'm cautioning you to beware of probate tax planning. So Ontario charges a tax on the value of all assets that pass through a will, which is admitted to probate. So what is probate? Probate's a term which applies to a certificate that's issued by the Ontario court, which certifies that this is the last will and testament of a deceased person. And the estate trustees or executors are required to apply for probate in order to deal with some certain assets. So a person dies, they leave a will, they appoint executors. Those executors need to apply for probate to prove that this is the last will. So this estate administration tax is the amount of tax payable on the issuance of a certificate of appointment. And it's $5 for each 1,000 up to a certain amount, and $15 for each 1,000 for the value of the estate that exceeds $50,000. So it's basically 1.5% of the value of your assets. So on an estate with assets having a value of $1 million, probate tax is $14,500. Now that's not a lot compared to how quickly legal fees can run up if you're trying to avoid this. So generally, if your estate comprises bank accounts, brokerage accounts, or real estate, your executors must apply for probate. However, shares in private corporations or jointly held property do not require probate. In the case of jointly held property, on the death of one joint owner, the surviving joint owner accedes to the property. So no need for probate. You just register a death certificate to transfer the property. Shares in private corporations also don't need probate. For that reason, many individuals choose to have two wills, one which deals with assets that have to go through probate, and another which deals with property that does not require probate. Now, many individuals will hold their property jointly in order to avoid probate, or they will use what is often called an alter ego trust or a joint partner trust. These are very, the latter, alter ego trusts and joint partner trusts, are very popular in British Columbia because it avoids some of their will legislation. I find that they're very expensive and difficult to manage, so they're less popular in Ontario. An alter ego trust is a trust made during your life under which the settlor, the person who sets up the trust, is the sole beneficiary of the assets transferred to the trust. What are the hallmarks of holding property jointly? Usually husbands and wives own property jointly. So when property is held on joint account, each joint tenant is entitled to an undivided interest in the whole property. If a joint tenant dies, the other joint tenant automatically becomes the owner on the death of the first to die. So for this reason, joint property does not pass through a will. It automatically devolves upon the surviving joint tenant by right of survivorship. When should you hold property jointly? So the only time you should hold property jointly is when you want the other person to have rights now and inherit the property on your death. So most spouses will own their property jointly. The problem is that some individuals have decided that to avoid probate tax, they will place their property in joint tenancy with one or more children. Where property is held on joint account for convenience purposes or to avoid probate, this is not a true joint tenancy. So for example, if a parent is becoming elderly and wants to have one or more children have signing authority, this is not a true joint tenancy. Rather, the child who has signing authority holds this property on resulting trust for the parent. The intention is, in this instance, to have the property disposed of, perhaps in accordance with the parent's will, or perhaps in accordance with written or oral directions that are given by that parent. I can't tell you how often this happens. A parent places property in joint tenancy for convenient purposes, And then on the death of the parent, the sibling or the child who has the joint property does not share with the other siblings. So the probate tax on an estimated estate valued at approximately $1 million is $14,500. The cost of litigation over who owns that joint property is far in excess of that. So while it's tempting to avoid unnecessary tax, by far the most frequent source of litigation occurs as a consequence of using joint accounts or transferring property into the name of another person simply to avoid probate tax. So in an instance where a person uses joint accounts to avoid probate tax, or in reliance on the fact that the other joint tenant has agreed that they will distribute the funds as set out in the will, the forms for the application for probate specifically state that if a joint tenant holds property in trust, it's not a true joint tenancy. So you might go to all this trouble of placing it in joint tenancy, but the actual forms state if this is not a true joint tenancy, you have to pay probate tax on it. Okay, in your will, you may have made gifts to a number of charities, and you may have set out various terms and conditions under which your children and grandchildren will take the interest in your estate. All of this will be defeated if property has been placed in joint tenancy with an unscrupulous joint tenant. Now, this can be not just relatives. We've seen very frequently circumstances in which there is a trusted neighbor or a trusted caregiver, housekeeper, things like that. It happens very frequently. And again, the convenience of having another signing authority is often not worth it. And some banks will even have a joint account without right of survivorship that gives signing authority, but no rights on death. The other issue is that if you put it in the name of a child, and the child is not able to fulfill your wishes because they are incapable or perhaps not able to make decisions, it will be their spouse who will inherit. And what happens then? The spouse may not feel the same moral obligation to discharge the wishes of the parent. The use of joint tenancies was so frequent that 2 cases went to the Supreme Court of Canada, where they clarified the concepts of the presumption of resulting trust and the presumption of advancement. Now, the presumption of resulting trust is that if there is a gratuitous transfer of property where no money is paid by the transferee, the onus is placed on the transferee to demonstrate that a gift was intended. However, depending on the nature of the relationship between the transferor and transferee, the presumption of advancement may apply, and it will fall on the party challenging the transfer to rebut the presumption of a gift. So, in PCOR, the presumption of advancement was considered, and the Supreme Court decided that the presumption of advancement, which applies to state that when a parent gives money to a child, the parent is presumed to make a gift. But the Supreme Court decided that this presumption only applies for minor children. So if a parent places property in the name of a minor child, there is a presumption of a gift. If a parent places property in the name of an adult child, there is no presumption of a gift. There is a presumption of resulting trust, which means that that child owns in trust for the parent, and it is up to them to establish that a gift was intended. The presumption of advancement also is determined on a case-by-case basis, because there can be dependent adult children. It's usually thought that once you reach the age of 18, you are no longer a dependent. However, in certain circumstances, children who are adults can often be dependent. So in those circumstances, if a parent places property or money in the name of an adult child who is actually a dependent, that's strong evidence that a gift was intended. The presumption of advancement, or the presumption of a gift, also applies for spouses. Under the Family Law Act, it states quite clearly that the rule of law applying a presumption of resulting trust applies where a husband places property in the name of a wife, except where the husband or wife places property in joint tenancy. So where there's a joint tenancy, there's a presumption of gift. If the husband or wife places property in the name of the other, not jointly, there's a presumption of resulting trust. Ensuring your gifts are honored. We're moving now to the will. Making gifts to the charity that you intend. First of all, you have to ensure that you have the name of the charity correct. If the name is incorrect, or if the name has changed, there are a number of charities that fall within the description of the charitable purpose, then it may be necessary to apply to the court for advice and directions. These are called CPRE applications, and they're exceptionally expensive. This usually happens where the name of the charity has changed or is very similar to another charity. If you're making gift for a purpose, you have to ensure that the gift is for a charitable purpose and not one which is considered to be non-charitable, because the court will not enforce a non-charitable purpose. These include benevolent purposes. So a gift in trust for a non-charitable purpose may fail. In Canada, the following are the categories of activities or purposes which are considered to be exclusively charitable: the advancement of religion, the relief of poverty, the advancement of education, and objects beneficial to the community as a whole. Now, the area which causes the greatest concern is with sports or recreation. And for gifts to those, such as a camp, you have to fit within objects beneficial to the community as a whole. You need to ensure that your charity is going to be able to accept your gift. And my advice to you in these circumstances is to keep it simple and avoid restrictions or burdens. So acting for Catholic charities, we see very often circumstances where people have left a house, for example, to the Archdiocese to be used by the Archdiocese as a home for retired priests. So the Archdiocese is not in the business of operating homes for retired priests in private residences. That's the type of thing that they could not accept the gift for that purpose. So if the gift is worded in such a way to say, with the wish that it be treated as a home for retired priests, that's precatory and it's not a condition. But if it's a condition that the gift be used for a specified purpose and the charity can't use it for that purpose, then the gift will fail. For other charities, if you're talking about the Jesuits, for example, you may decide that you want to leave it for general purposes or for a specific purpose. But if the specific purpose is one that can't be fulfilled, again, it will fail. So if you have a gift and you want to make it for a specific purpose, there may be an endowment fund that is already in existence. You can add to that endowment fund. But it's important that unless it's a specific, or unless it's a gift of a sum of money to be used as the charity sees fit, you may run into difficulties, and you should talk to the charity beforehand. The charity might also have to decline the gift because it's not able to fulfill the purpose, or because it would be too costly to fulfill the purpose. So generally, any gift which has a burden attached runs the risk that the charity will not be able to fulfill that purpose or shoulder the burden. So always check with the charity beforehand to facilitate and ensure that your gift is going to be accepted. In general, a charity will prefer to receive cash or marketable securities, or at least property with no restrictions, so that they can monetize the property. Even if a testator leaves gifts to charity, the gift may be to fulfill a purpose which is impractical. So for example, often we will see a testator stipulate that the fund be invested and used to sponsor a lecture series on an annual basis. If the fund is unlikely to produce sufficient income to sponsor such a lecture series, the charity may have to decline or take action to vary the trust. A variation of trust involves an expensive court application, which results in less funds being available for your beneficiaries. The next topic is avoiding challenges to your will. And here we're going to deal with gifts to charity and when these can be set aside. And when I first started practicing a long time ago, I seemed to spend half my time dealing with gifts to charities that were challenged by any one of a number of people, disappointed beneficiaries, the housekeeper, often on a regular basis. So when can a gift to charity be set aside, challenged, or defeated? They are often challenged by relatives or beneficiaries under a previous will, or persons who claim to have been promised property in exchange for services. Testators often will leave small amounts to their beneficiaries and the bulk of their estate to charity. Those beneficiaries will often challenge the will. They can say that the testator lacked testamentary capacity, or that someone or some person was exerting undue influence over the testator. These challenges can often occur if the testator had no history of benefiting the specified charity, or if the will under which the charity is to receive the bequest is radically different from previous wills. So a child cannot make a claim under dependent relief legislation unless that child was a dependent of the deceased. However, there are many instances where children have made claims against the estate on the basis that they were promised a specified portion of that estate. So for example, if an elderly parent has been living with one or more of his children, the children often have an expectation that they will be receiving some recognition in the will, or at least some compensation from the estate for the cost and expense and inconvenience of maintaining the elderly parent. Or the testator might stipulate that if he or she is able to live with the family, or if they resided in their own home and were taking care of that child would inherit. Or where there are multiple children, that the child who is performing the service will reserve a greater share of the estate. Now, the basis of this claim is called quantum meruit. That means that the family member providing services without compensation has some expectation that they would receive some portion of the testator's estate. So in certain circumstances, the courts will enforce that bargain, and they will either transfer the property to the person claiming entitlement, or at least provide the disappointed beneficiaries with a monetary amount to compensate for the services. There's an adage that charity begins at home. So if a testator has dependents, they should be taken care of. If a testator has incurred debts or made promises to pay for services, they should be paid. Charities are often placed in a difficult position when family members or friends who have provided services and had legitimate expectations challenge a will. And although a charity has a fiduciary duty to receive funds that are left to it, many charities will find it difficult to mount a vigorous defense to a claim by a family member, particularly where there is a possibility of adverse publicity. And having acted for charities for years, I can tell you, I don't know any charities that play hardball when a family member is involved. Oh, we're at the end already, and we have lots of time for questions, I see.
We do, Rosanne. Sorry. Thank you very much. That was very informative. And I'm sure people will have more questions as we go through the questions and answers we have already. Just a reminder, if you have a question, please ask in the Q&A box down below. And I'll moderate the questions and answers. And in the interest of saving time, I may edit some of your questions for brevity. So my apologies in advance. The first question is, can estate planning be done in steps instead of a marathon meeting with legal teams?
Okay. The answer is yes. And as a matter of fact, usually estate planning takes at least a year, maybe depending on the size of your estate and the complexity, a little longer. So I find it easier to start with the powers of attorney for personal care and property. Those seem to be a little easier to manage. They're short, they're sweet. Get them out of the way first, and then concentrate on the will afterwards. So yeah, that's what I would recommend.
Thanks, Rosanne. Next question. Is it possible to hire someone for personal care? Since my perception has always been that illness can be long and drawn out and difficult to monetize. So it might be hard to meet the needs of either the grantor or the attorney for care, since it would be hard to negotiate ahead of time.
Okay, so there are circumstances. I assume we're dealing here with the person who is the attorney for personal care does not have the responsibility to look after the person physically. They have the responsibility of arranging for the actual personal care. Because sometimes people need round-the-clock nursing care, or sometimes they just need to be, the attorney will simply set up, how should I say, they will set up programs for the individual, but usually there is someone who has to be hired to take that person to their various programs, for example, to the dementia programs that exist. But if somebody is in the situation of requiring round-the-clock care, obviously you have to hire somebody. I hope I've answered that question, but maybe whoever asked that, if I didn't answer that, please submit a follow-up question.
Thank you, Rosanne. Next question, when describing, now the quote is ademption, a situation was described where an asset liquidation might become problematic if there were previously services promised. Can you name a situation when there is a beneficiary and some reciprocal services? It almost seems like an evasion of taxes. And of course, you wouldn't recommend that, right, Rosanne?
No, I wouldn't recommend that. But when I talk about services, This frequently happens with family members where somebody says, let's say that there's a grandparent says to a grandchild, I don't want to go to a nursing home. I want to stay in my own home, but I'm concerned that I might slip and fall, etc. And I'm no longer driving. If you live with me in the home and permit me to stay there for as long as I can, and because you've got a car, you can do the grocery shopping, you can take me shopping, you can take me to the doctors, then when I die, you can have the home. That person, that grandchild who moves in and performs these services does so on the expectation that he will be compensated afterwards. I don't think Canada Revenue Agency ever expects there to be payments between family members. And so it doesn't strike me as wrong that the child isn't including the value of the house in his or her income on a death situation. But you also referred to redemption, and if there comes a point where the grandparent can no longer live in the house, even with the assistance of the grandchild, it may be that the house has to be sold. And in that case, what happens to the grandchild? They have been promised compensation or that they will inherit. So in that circumstance, you might have to have a court application, or the family may have to decide. If we sell the house, then the grandchild might receive, say, a specified amount. But that's the type of thing that would have to happen when somebody has really put themselves out to permit that grandparent to stay there.
Okay. Good. Thank you, Rosanne. Next question. Does the attorney for personal care receive any monetary compensation upon the death of the grantor? Also, who or how is the decision made that the grantor is incapable of making their own decisions? That's a big question, but.
Okay, so under the Substitute Decision Act, it was thought that there could be no compensation for services rendered as a attorney for personal care. But I have seen circumstances where the court has awarded compensation, and it's generally on the basis of the value of the services rendered. So if that individual was, how should I say, attending every day to deliver groceries, or depending on what services they rendered, they would be compensated on a quantum merit basis on certainly more than minimum wage payment. But it usually for personal care, it's done on a court application, on a passing of the accounts. The attorneys for property are entitled to compensation based on a sliding scale, which is basically 2.5% of all revenue and capital received and dispersed, plus a care and management fee of 3/5 of 1%, which is quite generous. So, and yet the attorney who is looking after the personal care doesn't have the benefit of that sliding scale. So that tariff, it's called, but they would be entitled to some type of compensation.
Thank you. This next question was asked by two people, almost using exactly the same wording. So, can a family member or anyone challenge an insurance policy that has been designated to a charity?
let me see. So insurance policy. See, the designation of an insurance policy is not considered to be a testamentary document, and challenges to wills generally come under the Succession Law Reform Act or something which is a testamentary document, which includes an RRSP, but not necessarily an insurance policy. So I'm not sure about that. But, you know, now that I think about it, this happens frequently when you are going to make a donation to a charity of the premiums on the insurance policy. And instead of getting, you know, let's assume that the premiums on the insurance policy are $1,000 a year, you would get a receipt for $1,000 annually, but on your death, the insurance policy might be worth $100,000. So doing that is a good way of providing a really outsized gift to a charity compared to the donation that you've made. So that's done frequently. But if I've, again, if I haven't responded fully or completely, please ask again.
Thank you, Rosanne. The next question, I'll paraphrase it a little bit. Well, when recently designating or describing, the legal name of a charity to a major bank for RSP purposes, I'm assuming the charity is going to be the beneficiary. Mm-hmm. The name had to be abbreviated. In this case, it was the Archdiocese of Toronto, which is a very, very, very long name. It was a challenge for the bank. So the question is, will this be a problem when it comes time to distribute the funds?
You know, I often find that people will, for the Catholic Church in particular, they'll donate to a parish, which of course is not an entity. And I don't have any difficulty when I tell them, no, it goes to the RCEC. So I don't think it would be problematic to use an abbreviation. The RCE, I would use the RCEC because that's what banks are most familiar with. And again, as I say, frequently they will designate a parish, in which case it automatically goes to the RCEC. And I don't have any difficulty with banks recognizing that. So,
yeah, I would just concur that in our experience, we see many wills that have a number of beneficiaries, and because of our location, the Archdiocese is also a beneficiary, and typically it is just RCEC. Mm-hmm. I will tell you that Jesuit Seminary Association will fit in every bank RSP template. So you can always put that. There are no more questions that have popped up in the Q&A box. If anyone has a last minute question, oh, there's one. See, that always works. How or by who is it decided if the grantor has the capability of making his or her own decisions with regard to personal care? And I think this might be a follow-up from an earlier question.
Mm-hmm. So usually the grantor will acknowledge, I mean, it'll be readily apparent that the grantor does not have the ability to make their own decisions relating to personal care. They won't be able to feed themselves or whatever. If they will not acknowledge it, then you have to have a capacity assessor, and the capacity assessor will come in, and they're not doctors, they're usually social workers with specific training for assessing capacity. And there are certain circumstances where you have to have a guardian of the person appointed, because and that occurs when the person does not acknowledge that they are incapable. They are entitled to have their own lawyer and they are entitled to have input to the extent that they are able. So, so where you have these type of applications, the court always ensures that the individual has their own, it's called a Section 6 lawyer, and they have input into any decisions that are made on their behalf.
Thank you, Rosanne. And I know those things can become very long and drawn out and expensive at times. But I see no more questions. Oh, sorry. I'd be here all day if I do this, but that's okay. Okay, can an estate account be set up much later after a death so resources can be deployed? For example, having a person out of town and accessing finances and keeping a distance was an afterthought and allows breathing room pacing.
Okay, so an estate bank account can be set up much later after death, so long as you have the documents that the bank requires, which would be a probated copy of the will. In Toronto, it's taking at least 3 months to have a will probated, 3 to 4 months. During COVID, it was taking a year. So frequently bank accounts, estate accounts aren't set up until much later. I was giving a talk though at a law society program on problems that I see with complex estates. And one of them is, it makes me crazy when people use a corporation or a lawyer's trust account to make payments of basically transact the estate business through a lawyer's trust account or through a corporation. And I said, you know, you should open a bank account. And somebody said, when was the last time you tried to open an estate bank account? And it's true, they have become impossible to deal with. There are some banks that are better than others, but some banks, it's impossible to open an estate bank account. So I always encourage clients to keep the deceased bank account open and see if you can just convert it into an estate bank account rather than open one separately. Trust accounts and estate bank accounts are very, very difficult. And if they won't do that, then you really have to get the matter elevated to somebody at the top of the food chain at the bank branch. And sometimes it means going even beyond the bank branch. It's unfortunate, but it's one of the frustrations that has been fairly recent. I would say the last 10 years.
Thank you for that, Rosanne. Now I'll try one more time. I see no more questions, but if you have one last minute question, we probably do have time. If not, I will say thank you very much.
Barry, would you like to take a few minutes to say what type of bequests you frequently see or would prefer?
Oh, I didn't think I'd get a question, but okay. I'm happy to answer the question. I mean, we're happy to receive, you know, we're happy that our donors, our benefactors, our friends want to support us, but there are some practicalities with some gifts. I mean, the easiest thing for us to process and to deal with, and the most cut and dried with auditors and CRA and everything, is cash or cash equivalents. And we take every kind of cash you can think of, even e-transfer. Marketable securities are also very much appreciated, and there are some tax savings if you donate marketable securities. Other things get a little more complicated. As Rosanne pointed out earlier, if you give us a gift with a whole lot of conditions, there are issues because we can't always fulfill all the conditions, and we can't accept the gift. And the other side to that is to get an official tax receipt. The gift must be given without strings. It must be given for no consideration. So we get into situations where you're asking us to buy this with the gift and that kind of thing, and that's complicated. Other what are called gifts in kind we kind of deal with on a case-by-case basis. If you want to give us a piece of art, we have to go through a kind of an appraisal process and that kind of thing. And then we also have to be honest and say if we really have anything to do with this piece of art, or are you asking us to keep it forever, or can we sell it? So that's kind of cash is king. My wife is Italian, so she'll always say cash is king. But anyway, we are pleased to work with you with anything else you'd like to chat about, for sure. In Canada, unlike the US, we don't have much giving up here through insurance policies, as Rosanne was speaking about earlier. It should probably be more developed, but I know the Jesuits in the US do a lot with insurance policies, and their laws are slightly different than ours. Did that answer your question, Rosanne?
Yeah, and just getting back to the insurance, I know that it depends on who in the advancement office is working with your people. And the insurance policies, the cheaper they are when they're issued when people are young. Right. So usually somebody from the advancement office will target a group of people. If you're insurable, it's a great way to get more bang for your buck, as it were. And I know that some of the other Catholic charities do that frequently. Mm-hmm.
Thank you. We'll be calling you tomorrow, Rosanne, for that. Okay.
Oh, here comes another question.
So I'll see what happens. Here we go. I spent a great deal of time trying to hire personal care help for a person who became bedridden in her last days. I have lost about 6 months off of my life with stress.
Yeah, that is why I said it's, or do you get compensation? I guess it depends on whether or not you were appointed as the attorney for personal care, or whether you just did this out of the goodness of your heart. You know, in families, it usually falls upon one member of the family to provide that. Oh, it says, yes, you were appointed. Yes, you should be entitled to compensation. And I think that if you speak to the executor and prepare a list of what you did, then you should be entitled to some compensation. It should be similar to what would be charged by somebody who did this for a living. Yes, she had no relatives here in Canada, so that's why you were appointed as the attorney for personal care, and you did all the work. So yes, you ought to be. You ought to be, and if you weren't, then I would speak to the executor.
Thank you, Rosanne.
Mm-hmm.
So once again, thank you very much. That was very, very informative. I'd like to let you know that a link to this entire presentation, including the questions and answers, will be sent to the email address that you registered with. So if you missed something, you'll be able to rewatch everything again. And if you have any questions, reply to that email. And I mean, we don't have Rosanne's services forever and ever and ever, but I'm certain she'd be able to help if we had any specific questions relating to this presentation. So thank you again, Rosanne, for the very instructive presentation. And thank you all for joining us. The Jesuits of Canada are always most grateful for your support, generosity, and prayers, and they in turn keep you in their prayers daily. Thank you and have a good afternoon.